Well, good morning, good morning, good morning. Setting up my system for court date. Today is the 17th of February. My last court date was the 26th, I believe, of January, which there were some technical difficulties and they had to postpone until today. So I'm setting up now the system to receive my court date. So bless up. We'll be back. I'm in holding pattern, waiting for the meeting to start. Yep. I'm in holding pattern, waiting for the meeting to start. Let's see. Let's turn this camera around towards the screen. guess we'll dive in here. See if this meeting is set. $10:15. Waiting in the wings. Seems like the audio is working. I just muted myself. I actually heard the beep 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 when the system came alive. So I guess we're on a 15-minute holding pattern here because the hearing is at...
Attorney Twombly, Jennifer in the courtroom, can you hear me okay?
I can hear you. Good morning.
Good morning. We'll be with you in a few minutes, okay?
Very good. Thank you.
Never asked if I can hear her okay. come back in when court starts. Yes, I can hear you okay. Good morning.
Good morning. All right, we will be right with you.
Ten 22.
Thank you. You may be seated.
Area Court of Vermont is now in session. The Honorable Daniel P. Richardson presiding. The matter before the court is 74 South Main Limited Company versus in Dunbar. Case number 25 CV 02077. Get Attorney Twombly on WebEx, and we get the defendant Ken Dunbar also on WebEx.
Okay, good morning, everyone. We are here in continuation of the pretrial conference that we started approximately, I think, 2 weeks ago, but had some issues with sound. Let me start off by asking and just making sure, can everyone hear me?
Good morning, Your Honor. Yes, I can hear you.
Good morning, Your Honor. Yes,
Okay.
I can hear you.
Great, and based on those responses, I can hear both of you as well. So we are at least 2 steps ahead of where we were last time, and I appreciate that. So last time we were starting to talk about whether or not there had been compliance with the court's order in regards to the mediation that the court had ordered the parties to go to. And I believe Attorney Twombly, you had indicated that you had attempted to begin the mediation process, and that your understanding was that Mr. Dunbar was refusing to participate in mediation. Is that correct?
That would be correct, Your Honor.
And I think where the hearing kind of broke down for sound qualities and technical reasons was when I was turning to you, Mr. Dunbar, as to your response to that. So I want to give you that opportunity to respond now. My understanding is that from what Attorney Twombly is that you've refused to participate in mediation. Is that correct?
In answer to the question of not wanting to or refusing mediation, that mediation, I was told by Mr. Twombly, and I have a document proving it, was going to cost me $400 to $800 to have that mediation. I made a recommendation to him to meet with me. I don't understand what there is to mediate. He owns the apartment. He's been here many, many times to see the damages in this apartment. So I recommended that he come by. He came by, for which I filmed our meeting. We had our discussion. He came through again and with a pen and a paper, and he took a prize of the damages, which would be actually about the 4th time he's been here to do that, along with his workmen, which was our attempt at coming to some agreement. We spoke of agreement in that meeting, and that meeting is available. I filmed it. It's available on YouTube if somebody wants to take a look at it, and you can hear Mr. Twombly's words personally about his intentions here. So as far as mediation is concerned, I don't understand what there is to mediate, Your Honor. I'm a tenant. He's in discrepancy with the repairs in his apartment. He's in violation. I've had the health department inspector here, and still till to date, as we sit here now, none of the repairs that were promised, even from our last meeting, have even started. And in all actuality, the reason why money wasn't paid to him or money fell into arrears, mind you, I've been here almost 20 years. And I've had no problem with the past landlord for at least 16, 17 of those years before this gentleman took over the building. And he's let the building fall into, really poor shape. And for a long time, he's had me personally, having to deal with the discrepancies. For almost a year and a half, I had to walk up and down stairs here that were missing, and only moments before he served me with those papers did he send his repairman to fix one step. Mind you, that was just an hour before the sheriff showed up here to serve me papers. And he only started making repairs here a day after he showed up in court. And he says that these repairs were repairs that were, initiated by the health department. And the most important ones he makes reference to. I've asked him for a copy, and I've also called the health department to have a copy of the report. I haven't yet been privileged to have a copy of the report that he was furnished by the health department. So we've got a bag of issues here, Your Honor, and I would like to present my case in front of a jury and bring my evidence forward, to the court to have you fairly decide, where this needs to go. We're now quite a few more months into this, a 15-minute status hearing, which could have happened many, many months ago. He's known of these damages here for a very long time, not just from my mouth, but from neighbors' mouth. And I'm still living in this, as we sit today. I've paid my money to the court. You've asked me to pay my money to the court. I've had no problem with that. And that's my intention, to stay in that status. Been here 19 years, and I feel that I've been intimidated. I feel that I've been falsely represented. And I also feel that he's made promises to me and the veteran services, because I've had veterans behind me to help me, keep this situation, my living situation, on level. We all know the situations today for veterans. I'm 76 years old. I'm doing my best to hold myself stable. And this has all been under duress and so unnecessary. This gentleman could have just taken the responsibility, stepped up, made the repairs. I offered him his money and told him as soon as he starts making these repairs, I would graciously start paying him his money. But he would not start making repairs, or his schedule did not meet one that was satisfactory to, I'm frustrated, Your Honor. I'd like to bring this in front of a court, present my evidence. The house is still in violation. There are still things here that need to be done. He's just been here to this place to see it again, for the fourth time. And I actually asked him, are you here as the landlord? Or are you here as a lawyer? I mean, this is the hard part of this, because I'm not dealing with a person whose ownership of this home is in his soul, like the last two gentlemen were here. We had a wonderful relationship, almost 16 years with these gentlemen. No problem with them. As a matter of fact, they considered me an asset to the property because I looked after the property. I helped out when, help was needed. They can call me if there was an emergency because I was that one soul on the place to do that. I was hoping to have that relationship with this man, but, he defaulted quite early, and he put me in a position of discomfort for which I'm still sitting in today. And, it's, it shouldn't be like this. I'd like to bring my case. I'd like to bring my case and my evidence before the court and before the jury. I've given this gentleman the opportunity. He's said to me in our last meeting, which was just 2 days before we were in court last time, and he drew out some kind of little plan that he wanted to do, and I was willing to work with him. I haven't heard back from him again till I'm seeing him now in court, but I don't know. He's not a man of his word.
Okay. So, Mr. Dunbar, thank you for that.
Thank you for hearing me.
I want to be very clear, though. When the court orders parties to do something, the expectation of the court that they will do it. If they feel that they cannot do it, then it is on the party to file a motion with the court. And went through a number of these issues back late last year about why the court felt mediation was an appropriate next step in this case. And you made, Mr. Dunbar, a number of those arguments that you just made now, that you want to go to a jury. That's fine. But the court made the determination that mediation was appropriate. And what I'm hearing from you, that mediation never occurred. So at this point in time, the court has a couple of decisions to make. Because normally, when a party does not comply with an order of the court, then the court may impose sanctions on the party. And those sanctions can be money. Sanctions can be fulfill of claims. Those sanctions can take other forms as well, such as adverse rulings, stripping away certain processes that are responsible for or as a result of the non-compliance. And the ultimate goal in those sanctions is to compel compliance. And so courts have dismissed outright individuals' counterclaims for failing to comply with mediation requirements or showing good faith. At this point in time, Mr. Dunbar, I'm somewhat frustrated by your response, because I understand that you feel that there's very little grounds to come to terms with Mr. Twombly, either in his capacity as an attorney or his capacity as landlord. But nevertheless, the court required a mediation to occur. And if you felt it was not proper after subsequent facts, you needed to make a motion to the court to be excused from that mediation order. And part of why we're here several months later is because you did not do that. And that is on you. At this point, however, I've looked at the file, considered how best to move forward, and the problem was it's very clear that any sanctions that the court imposes on you, Mr. Dunbar, is not going to compel the ultimate result that the court was hoping and anticipating within the order, which was good faith participation in mediation. And so simply imposing a further sanction to compel your compliance isn't going to get you to come to the table in good faith. And for those reasons, I think that ultimately errs against Attorney Twombly and his client, who are entitled to either move forward on this case or to have a good faith litigation. Imposing any type of civil contempt on this at this point, I think, would be an exercise in futility. But I raise this issue because, Mr. Dunbar, as we go forward in the trial, the orders of the court will be the orders of the court. And if there is not compliance with the orders of the court, then you will be in contempt, and it can cause anything from a loss of your claims to a mistrial determination, in which case you would be responsible for Attorney Twombly's attorney's fees to handle the new trial. So if we move towards a jury trial, I want to be very clear that you have to follow the orders of the court, even if you disagree with them. And I don't expect you to agree with every single ruling of the court. I don't expect Attorney Twombly to agree with every ruling of the court. The court looks to the law and its understanding and applies it as it best understands the law. It's not intended to give either side any advantage and favors. It is intended to follow what it is required to do under the rules of civil procedure and under the statutory provisions of the law. So that's going to be extremely important, and I would consider this your warning to let you know that going forward, the court will expect you to comply with court orders. So, for example, if we go forward to court and Attorney Twombly makes a motion that the court grants that certain information is not admissible, and you go forward and try and present that evidence despite a court ruling that it is not admissible, then you will be in violation of the court's order. And so I want you to have your day in court. I want you to have your opportunity to be heard. If you want a jury trial, is what you will get. But jury trials come with rules. They come with full orders and directions from the court. The jury is a fact finder. A jury is here to make factual findings on the contested factual issues. They are not there to decide the law. The law is decided by the court. And so it's particularly important that you listen to the court's orders and rulings and you abide by them. Because if you do not, the court has the power to contempt, the court has the power to impose sanctions, and the court has the power to, in its most sort of ultimate stance, declare a mistrial if there's bad behavior that has tainted the jury process. And when a mistrial is declared, the party who created the mistrial is subject to the penalties, whether they prevail on the merits of the case or not. They are subject to the costs and sanctions for such an action. And I just want to make that very clear, because while I'm going to move forward have this case move forward, it is particularly important that as we go forward, you understand, Mr. Dunbar, that the orders of the court are the orders of the court. And that under other circumstances, the court would be imposing sanctions at this point for the non-compliance with its order, and would be holding a contempt hearing to that effect. But given what the court has reviewed and its considerations in the general sense of how best to move this case forward, how best to gain compliance, and I want to be very clear, civil contempt is not about punitive measures. It's not about punishing. It is very much about gaining compliance. And the court, in its original order, had issued an order that the parties go to mediation. And the reasons it stated at the time, and would repeat here today, is because ultimately what the court hears in this dispute is a tenant who wishes to remain at the property and continue living in his long-term apartment and wants repairs done. And there is a disconnect. And what I hear from the plaintiff is, I have a tenant who's not paying his rent. And I am taking steps to address repairs and needed issues, but I'm not receiving the rental payments, and I haven't received proper notice about a number of these things that would have justified the initial withholding. Obviously, these are contradictory positions, and there's some dispute as to the nature of the facts, and that's why it would ultimately go to a jury. But the reason for mediation is that ultimately these are resolvable, which is to say, repairs can be done, rent can be resumed, and a rental relationship can be restored. And there is a far quicker way than a jury trial to get one. And the risks in a jury trial are substantial. And I would just say, Mr. Dunbar, you just did in October a jury trial involving a landlord. And a self-represented tenant came forward with her claims, and she struggled with a jury trial because there are rules and standards to that. And so while I've got her day in court, an opportunity to tell her story, she ultimately did not prevail. And I only offer that because I want you to understand the risks involved in going forward. And I offer that as such, but I also recognize that you are very much of a mind that you wish to go forward to a jury trial. So what we're going to do is we're going to, at this point, I'm going to issue a pre-trial order, and we're going to set this for a jury draw I think April is going to be our jury draw, and we will set jury dates off of that. Let me message staff about that. Mr. Twombly, is there anything that you need to add at this point?
Well, Your Honor, Mr. Dunbar went through about 5 or 10 minutes of presentation of his case and a summary of his case, most of which I would disagree with, and I don't want to belabor the court at this time with it, but a lot of what was said was simply not accurate. And if the court wants to hear it, I can rebut it if that would be helpful to the court. But
I don't think it's necessary, only because I'm not taking testimony, and ultimately these are decisions that we're going to be setting for a jury. And so I'm more concerned, and I obviously the court's central concern was that it ordered mediation. All right, I'm seeing that we don't have our April jury dates set down. So what's going to happen next is that the court is going to put this onto our jury draw list. We're going to set this. We're going to set this for a March 26th free trial. So at that point in time, we will have the jury dates, and we'll assign this. Let me ask this Attorney Twombly first, and then Mr. Dunbar. How long do you expect
Thank you,
for
thank
jury
you.
trial?
I just need more honey and
Okay, we mute Miss Captain. I think you might be the next case. Okay. So, Attorney Twombly, how many days do you think for a jury trial do you need?
I see it as a fairly simple case.
You can ask jurors questions like, for example, have any of them been tenants? Have any of them been landlords? Have any of them been evicted?
Okay.
Have any of them had to evict someone?
I understand now.
Whether or not they would be able to hear the evidence fairly, and simply because somebody was a landlord doesn't mean that they would not be able to hear the case fairly. It's just you would have to find out whether as a result of their being a landlord, they would be able to hear evidence about supposed breach of the lease and any failure to repair claims that you have in a fair and open manner. Not be an opportunity for you at that time to make your case and the details. And in fact, if you do, that would be one of the points in time where the court would likely tell you to pull back from those details, because that's not the intent of the voir dire. It's just simply to determine whether or not any juror has a bias that can be overcome, and to set 12 unbiased, as close to unbiased jurors as possible. and then the next day would not necessarily the next calendar day, but the next day of trial would be scheduled, and that would be the day where everyone would put on their evidence. And at the end of that evidence, you would make your final arguments. The court would instruct the jury on the law, and then the jury would go and deliberate and make a determination on the claims.
Gotcha. Well, I agree then. I guess the 1 day selection process, I guess, would be, if that's what you're making reference to. Yeah, I agree with that.
Okay. All right. Well, we will go from there. We'll set this for the pretrial, the final three trials on March 26th. And at that point in time, we'll have dates ready for jury draws and trial dates. We'll go from there. And as I said, the court will issue a final pretrial order giving the schedule for any notices, either continuances or motions in limine. And we'll go from there. Attorney Twombly, you had one other issue you wanted to address?
Certainly, Your Honor. Thank you for the opportunity. I had hoped that the court would require the mediation and still would request that the court do it. And I'll tell you why. Because I think that someone impartial who could give, as much as anything else, some neutral evaluation would be helpful to bringing the dispute to some kind of appropriate resolution that would be acceptable to myself and to Mr. Dunbar. Mr. Dunbar has been somewhat rigid about this, and quite frankly, I don't see the issues as all that complicated as requiring a lot of process. And I'm made it clear to Mr. Dunbar that I'm willing to work out something that would enable him to remain as a tenant. I know that he's been there a long time. It's not accurate that I haven't been willing to have him there as a tenant. The risk, if he goes forward, is that those kinds of things are off the table, and he might have a judgment for possession against him, and in that situation would not be able to remain as a tenant. The issues are straightforward. The important repairs that he mentioned have been done. The kinds of things that he's looking at now are redecorating, in the nature of redecorating and renovations, and I'm even open to some of that. To put this kind of time and energy into a jury trial seems, I'm not sure what the motive is. As he says, he's recorded his other parts of this and put it on YouTube, so there's a little bit of showmanship perhaps going on, and broadcasting to the public that might be interested in it. But I certainly see the issues as more cut and dried, and I'm certainly willing to do the part that is expected of a landlord, and perhaps a bit more. So I think Mr. Dunbar would benefit, as would I, from some neutral evaluation by a mediator who could confer privately with me and confer privately with Mr. Dunbar and point out where a case like this would likely end up, and try to take a more abbreviated process toward coming to a resolution. I'm not approaching this with anger or anything like that. I just want to see it get done. I want to see a fair result. I want to see Mr. Dunbar feel properly treated, and I want to feel properly treated. And I think that the court demonstrated wisdom in trying to impose that, and I would still ask that somehow the court revisit that issue and think of it as much as anything as neutral evaluation.
Okay. Mr. Dunbar, any response to that?
I think it's a little too late for that. We've been through this time and time again. This is over a year now, just in this process here, and he makes reference to repairs that were the most important. I still don't know what the health department requested, and I was the one that requested the health department inspection, and they still haven't given me a copy of the report. And so for him to say the most important is fruitless. I still don't know. I know there are violations here, and I'm still living with them till today. So I would like to move this forward, Your Honor. Mediation, he's had all this time to start the process, and here we are. You know, I'm ready to go to jury. I mean, I just lost family. I just lost family in the Caribbean in this big hurricane that hit. I haven't been able to attend their funerals because of this situation. I just lost a cousin on my birthday, the 25th of January, as I was going to court for this. And my family's in Jamaica now. And I'm sitting here now still having to deal with this. So I'm heartbroken, you know. I'm ready to move forward with this and get this over with.
Okay.
Thank you, Your Honor.
Attorney Twombly, again, I would reiterate what I observed before, which is I think that there is a great deal of sense in mediation, and I'll address this to both parties. There remains a good way forward through mediation, and Mr. Dunbar, I do understand it can feel very all-consuming, all-encompassing to be involved in litigation, especially litigation that affects your housing, and I don't, I don't impose this. I didn't impose the mediation requirement, despite that long term, but because of that, because the court wanted to give a good way forward, because if you go to mediation, you come to a resolution. That's a far quicker and more efficient and more effective solution than a jury trial. But I understand from your statements that you do not wish to participate in mediation. And Attorney Twombly, why I think you're correct in that there would be benefits to both sides going to mediation. I also think that if we continue down this route of mediation, we risk the court is leery about imposing contempt on any party. But it's very clear from Mr. Dunbar's statements that, the only way he's going to get into mediation would be through some type of threat of contempt. And even then, I don't think that you would get the good faith participation that you would need from Mr. Dunbar to participate in mediation. And so in that respect, while I understand that you are foregoing some benefits by not participating in the mediation, I think it's also important that this case move forward and that you ultimately have a right to some remedy. And I think it is unfortunate because when you get to a point of a jury trial, now it becomes an either-or situation. It doesn't become about how do we find a solution that's mutually agreeable to both of us. It becomes a case where a tenant loses their apartment or the imposing penalties on a landlord. It becomes really sort of a much more higher stake, or what can happen in some cases is the landlord proves that they have a right to eviction. They may get the eviction, but they may not get the damages. The jury may not award those damages. But even in that case, that's not the solution that either party sounds like they want. The problem with trials and jury trials in particular is it's really out of the party's hands once you start down the road to a jury trial. And I think you know that, Attorney Twombly, because you've done jury trials. You know what they involve. But nevertheless, I feel compelled to say that is that these are situations that are difficult in some ways to de-escalate or to come to an amicable solution if it reaches the point of a jury trial. It tends to be an either or, and it's great if you can succeed and you feel like you've been vindicated. But in the court's experience, jury trials are unpredictable, but they do offer one thing, which is finality. And so, given Mr. Dunbar's statements and actions, the court is not going to invoke its contempt power, compel mediation at this point, because ultimately it finds that the ultimate purpose of mediation, as opposed to other compliance, it ultimately requires Mr. Dunbar to participate in mediation in good faith, and I find no evidence that he would participate in mediation in good faith, even if required to emotional compel. So I'm not going to require mediation. We are going to set this for a pretrial conference. What I would offer in the meantime, and I think this is what you were alluding to, Attorney Twombly, which is if the two parties can have a conversation for settlement and have a conversation that, where they can agree upon a neutral evaluator who could maybe make some of those determinations and agreements, that's certainly on the table. But I understand from your position, Attorney Twombly, the further you get towards trial, the less likely that is, because you're going to have to put in resources and time and expense to try this that are not insubstantial. But at this point in time, I don't find that continuing the mediation order would be a benefit to the plaintiff, and that it would invite the court to invoke its contempt power in a way that not necessarily a useful use of the contempt power. It would be closer to punitive rather than compelling type of good faith participation. I do share and continue to believe that mediation would be a very powerful way to resolve this case. But given the nature of where this case is at, we're going to go forward. What I will say as well, as far as the YouTube is concerned, the court cannot take independent evidence outside of court. So to the extent that you have put forward or created any YouTube pages, Mr. Dunbar, about this, that is strictly for the public, not for the purpose of this court, because that's not the judge. Neither the judge nor jury can do independent research on a case. It is, or fact finding. It has to be what comes into court. It's controlled by the rules of evidence. And so, to the extent that you're videotaping conversations with Attorney Twombly, they are not. They're not going to necessarily come into because they may be subject to the settlement limitation under Rule 408. And certainly the court itself is not going to go look up YouTube pages outside of court, because that would be contrary to what the court is allowed to do. So we will go forward on March 26th with our final pretrial. I would encourage the parties to have some conversation to see if there's some way of resolving this. Mr. Dunbar, if you're going to go forward with this jury trial, I certainly suggest that you do some research as to the legal issues surrounding a jury trial. And as I indicated before, it is not all straightforward. Some of it is intuitive, but there are a number of rules, provisions, and process that go with a jury trial that I would strongly encourage you to make yourself familiar with before this process.
Certainly, Your Honor. Thank you.
We'll see everyone on March 26th.
Yep.
Thank you, Your Honor.
Thank you, everybody.
Morning, Anik.
Good morning. You can hear me?
Hear you okay? You're good to go.
Great.
Saw my filing from yesterday,
Yeah, very good.
and I'll go back on mute till the court convenes again.
Okay.
Well, there you have it.